side. So that's going to be good. So logistically, what I'll start
recording in progress.
My name is Ken Vercammen. That's my law office is in Edison, and I'm kind of here to go over some things with wills and probate, but kind of steer people in the right direction so they just don't keep on putting off stuff. Because people become putter-offers, and then we get calls on Friday at 5 o'clock. I need to get power of attorney over my dad. I need to get a will done. I'm having surgery Monday. So the whole thing is try to get your stuff done now. So, oftentimes people ask me, Kenny, why do I need to have a will? Isn't everything going to my wife if it's joint? It goes, well, if everything was joint, that's correct, but that's not a reason not to have a will, because both you guys are not going to live forever. That's not doing planning. That's just hoping that you don't need to do any preparation. So think about if someone does not have a will, or if the will was not properly signed or prepared, the procedure to distribute assets becomes much, much more complicated. So let's say there's 3 kids. That means that all the kids need to agree upon who's going to be the administrator and sign a renunciation. That's it. And then that renunciation that's signed in front of a notary has to be filed with the surrogate and a fee paid. Well, that's in the states where everyone gets along. Sometimes people don't get along. So then one of the kids has to spend a lot of money to file a complaint in the Superior Court and order show cause to have them become the administrator. So most people aren't saying, boy, I want to give my kids more work or make them more complicated. No, most people says, listen, I want my kids to try to get along, and it's better if you prepare ahead of time. Also, so if it has to go through this court route, they're going to be spending $3-4 grand extra. Well, that's a lot more than the cost of a $500 will. Plus, if there's no will, then the administrator has to be bonded, and the bond fee is usually $1 grand per year. The other things you got to think about, if some people are younger, they don't have wills, they have minor children. Well, if something happens to both parents, a total stranger determines who gets custody of the kids. That's a Superior Court judge. So you usually don't want to have a judge do it. You'd rather decide who you want. Some people put off, who are young, having wills. Well, we can't really decide who's going to be the guardian. He goes, well, I'll make it easy for you. I'll say, if you couldn't come home for 2 weeks, who do you want to watch your kids? And they'll say, well, I guess my mom. Or, okay, good. Well, they're getting older. He goes, yeah, but they're the best person now. You can always do an update to the will at any point in time as you want. And also remember, if someone doesn't have spouse, children, close relatives, the state of New Jersey gets the assets if there's no will. Well, who would ever want the state of New Jersey to get their assets? So really think about, let's see, if there's no will, it often causes fights, aggravations, sometimes lawsuits amongst the family. So, when loved ones are grieving, you shouldn't give them one more thing to stress about and think about. So think about, for you, who do you want to get your assets? Who you don't want to get your assets? Remember, it's your right to do with your money what you want. If you want to leave most of your money to the Yellow Dog Society, hey, that's your right. So one of the things, though, when the surrogate does lectured with us, they warned people about trying to do online documents not prepared by an attorney, because they said their problems they always see, the biggest problems is when people do those, they don't sign them correctly, they're not done correctly, the witnesses aren't. So, think about, would you, in this day, would you try to do your own electrical work? Would you try to do your own plumbing work? Would you try to do your own oil? Probably not. it's best to have a professional do it. A professional that's going to do a self-proving will. And so the old system of doing wills was much more complicated. You take half a day off of work, drive to the attorney's office, fill out forms. And, right before COVID and during COVID, we realized, hey, let's try to make it easier. I'd say, so most attorneys now, they can email a questionnaire to someone. We have 2 questionnaires, one where someone has minor children, and the other, I call it the Elks Club one, where someone can fill out on their iPhone, where they're basically saying who's executor 1, who's executor 2, who's getting their stuff. Let's say, so the questionnaire is not that complicated. It's not that complicated because New Jersey did away with the New Jersey estate tax. Who would have thought New Jersey reduced a couple taxes, did away with the estate tax, and there's no inheritance tax if it's going to spouse, children, grandchildren, stepchildren. The inheritance tax, if it's going to brothers or sisters, is 15%. 11%. The first $25,000 is tax-free. If it's going to bona fide charities, churches, library, foundation, there's no tax. If it's going to out everyone else, there is a 15% tax, but most of those people would say, listen, I'm glad I'm getting something because otherwise I wouldn't get anything. All right, so the will questionnaire. You've typed in your name, then you're putting in who's executor 1, who's executor 2. You don't want to have joint executors. You're creating more work for them. Let's see. They could be twins living together, but why create more work for people? I was involved with an estate where they was foolish enough to have joint executors, and these 2 guys couldn't agree upon what color the sky was. Brother number 1 says the sky is blue. The other one says, no, the sky is gray. You're stupid. You've always been stupid. So there's a reason. There's only one president of the United States at a time. So you have a number 1, number 2. I mentioned the part about typing. Some of the seniors say, oh, I'm not good with a computer, etc. I goes, no problem. Let's resolve this. I'll say your daughter lives 2 towns over. Tell them come over in the next 3 weeks, and you're going to give them $5,000 to do it. If your granddaughter won't come over and visit you, and you're giving her $5,000, then you can say, no problem. You don't have to come over, but I won't leave anything for you in the will. We're trying to make things easy for people. Okay. So you're listing who gets your assets, what percentages or who gets it. And you always want to have a clause that would indicate if anyone passes away, who gets their share. Let's see. So if someone's saying, okay, it's getting divided equally amongst my 3 kids, that's good. If any of those children shall predecease, typically you want to go into their children, your grandchildren on that side, and if they don't have any grandchildren, it goes to the survivor. But remember, again, it's your right to do with your assets what you want. Now, I said that part, but certain assets don't pass under the will. They pass by title or contract. So examples of that are if someone has an IRA, 401k, something like that, automatically goes to the survivor. The will can't change that. Some people have, for example, house's own husband and wife, automatically goes to the surviving spouse. The will can't change that. Sometimes people are separated. I go, well, listen, I'd say, do you understand if you pass away, first your spouse gets that house and everything else. We have to, to change that. Both people would have to sign a deed, but at least sometimes people can change on their accounts if they're separated, who gets them. It's the same thing. If someone is separated, probably a good idea to do new power of attorney so you're not giving that spouse the power to do stuff. So, So write down assets. A will can't change if assets have a direct beneficiary. Now, it is a good idea to have direct beneficiaries because it makes it faster for people to, get things. We also recommend that people get an old-fashioned printout, make a photocopy or print it of, who gets assets directly. But you still want to have a will because there's always assets that do not have a direct beneficiary. All right. Next, specific bequest. What is a specific bequest? Specific bequest, you're specifically giving something to, someone. Sometimes the ladies say, I want my jewelry to go to this particular daughter or granddaughter. Sometimes the gentlemen say, I want my firearms to go to a particular person that has firearms permit. Some people have family things that they want to go to a particular person. Hey, that's fine. But I tell people, don't be crazy. One time a lady, she had 11 pages worth of stuff single-spaced, and it was just junk in the house that people would not have wanted. Now, also, you can give, some people give monies to charities. Now, I support giving money to charity, but I on the other hand, I warn people that if you give a percentage of an estate to a charity, that means the Attorney General has to get involved, and they have to approve the accounting. It's going to take them maybe a year to do that. If you just leave an amount to a charity, 10,000 to Saint Cecilia's Church, 10,000 to Our Lady of Peace, whatever you want. Then once they get their money, then the Attorney General's out, and the Attorney General's not requiring the accounting. So think about that when you're doing your bequest to charities. Yeah. In addition, we have what's we call the reverse specific bequest. I leave nothing to, and you name that person. You don't give them $1. You don't put a reason. Nothing to that person. Because again, it is your right to do. As long as you're competent, you can do what you want. Last year, a client had 4 kids, and she asked, do I have to treat all my kids equally? One of my sons lives on the West Coast. We don't hear much from him. I go, whoa, okay. I'll ask you a couple questions, ma'am. Did he send you a card or a call on Christmas, your birthday, or Mother's Day? He goes, nah, we haven't heard from him in a couple years. He goes, why would you give this bum anything? And the other thing with that kind of bum is if someone passed away, they would be the troublemaker that causes, the most problem. They'd be like, where's my money? Where's my money? So if more and more, by the way, people are not leaving their assets to their children. Not because they don't like their children. It's because their children could be grown. They already have their own house. And they'd rather give it to their grandkids to help pay for college and maybe for a wedding or things like that. So, now we do have a clause when they're young. They don't get the money outright when they're 18. If there's no will, by the way, they do get the money when they're 18. Instead, we usually say they get some when they're 22, 25, and 30, but the executor can expend as much money as is needed for health, education, maintenance, support. So my son went to, who's a South Brunswick grad and in the South Brunswick Sports Hall of Fame. He went to University of Miami. I read that the tuition there is $90,000 a year. So if think about maybe you want to give the money for grandkids. But again, importantly, have a clause that says they don't get when they're 18, because how many 18s would have done smart things with money? If there's minor children, you have someone set forth as the trustee of the money. It's usually the same person as the executor. The trustee, all they need to do is go to a brokerage account like Merrill Lynch and set up an account under that kid's social security number, but the person who controls it is that trustee. The guardian is the person who holds the children, the guardian of the children, and it can be the same person, it can be something different. So they don't have to, and they don't have to live in the United States. It's better, but sometimes clients goes, Kenny, I don't got anyone in the United States. Okay, fine. Okay, I've already said, I'm going to repeat it. Make sure you have a self-proving will. There was an old way of doing wills, and the person signed, and there's two witnesses, but then one of the two witnesses had to go and sign papers with the county surrogate saying they were the witness. And it became difficult sometimes to find a witness, or sometimes the witness would say, well, I won't do it unless you pay me $500. Self-proving will, person signs twice, the witnesses sign twice in front of the notary, then the notary or attorney signs twice. So make sure that you have the attorney do a self-proving will, and also have a clause that says no bond is required. Now, a will is good forever. I use the word. It never becomes obsolete. However, though, sometimes there's reasons to change the will. Our rule of thumb on the trustees is, can they drive to the bank and the surrogate's office and walk up a flight of steps? If they're old or disabled, maybe there's someone else in the family that can do it. People go, I feel bad. One of my oldest. I goes, don't have your oldest. Have the one who's the best. Next, only the original will can be admitted to probate, not a photocopy. It's still a good idea to scan it and email to yourself, Executor 1, Executor 2, the trustees. Let them know where the original's at. Don't put the original in a safe deposit box. People can't get to the safe deposit box. Let's see. Only, just get a fireproof box, throw it under the bed. Be careful leaving things in the basement, because periodically there's floods. There's usually never floods in people's bedrooms. So that's a little bit that you need to know about wills. Not that complicated. But the whole idea is getting things done. Get them done. Don't be a Carl. What's a Carl? Who's Carl? Carl was this retired engineer in Edison. And, he came in and I went over the things I recommended. And he goes, I want to read up on it. You know how those engineers are. They always want to read stuff. They want to read the manual on their car. I goes, Carl, you don't need to read anything. I went to law school. I passed the bar. I go to seminars. I give seminars. People, I wrote a book on this. You don't need to read anything. I said, Carl, when I had my knee surgery, I read nothing at all about knee surgeries. I just said to the doctor, do the best you can so I can be out running again. Let's see. All right, Carl, Carl wants to read up. 2 years later, Carl's daughter calls up. Do we have his will? Because she found our business card and some of our brochures. Answer, no. He wanted to read up on it. He never got it done, and the family got screwed. So if you don't have a will done, you're kind of screwing your family. It's like if you owned a house that had a basement and there's a pipe that's leaking and you just ignored it, saying, hey, I'll let my kids take care of that after I die. That's their problem, not mine. You wouldn't do that. You take care of it. So you don't need to read stuff. And by the way, some companies now provide what's called a wills through something called a legal plan. So I'm putting in the chat some of the companies that they may have different, either MetLife legal plan, ARAG legal plan, legalese. It's a good benefit for people. Next topic I'm going to talk about is revocable trusts. Let's say my mother-in-law lives in Monroe now, but when she was in her house, she'd call me every other year. She goes, I want to come in and get a trust done. I would say, why do you think you need to have a trust? Were you watching Susie Orman on TV? She says, oh, yes, I was. I go, Susie Orman is right if you live in New York, California, Florida, where the probate process is a nightmare. But New Jersey probate only costs $180. So I ask people, why do you think that you need to spend all this money having spending $3,000, $4,000, $6,000 setting up elaborate trusts? He goes, I want to avoid probate. Why? My friends said I should, but your friends don't live in New Jersey. Remember, us attorneys, we make more money when we do these trusts, but I want to be fair with people. Is it what they need? So, why don't people need to spend $5,000, $6,000 on a revocable trust? Probate in New Jersey is easy and expensive. To probate the will, all the surrogate needs is the original will, original death certificate, check for $180, and we prepare the information sheet.
Oh, you're back.
Let's see.
Can you just repeat the last 2 seconds? Because we lost you for a minute.
Okay. Are we on? Okay. So, to probate the will, you need the original will, death certificate, check for about $180. Let's see. The attorney typically will type up the information sheet for the surrogate. So once someone makes an appointment, the surrogate says, sign here, sign here, sign here, sign here, sign here, sign here. And then you're good to go. Okay? A revocable trust does not protect assets from nursing home. It doesn't protect assets from taxes. Some of the trust salesmen say, trust is confidential and a will is a public record. But who really care? If you're gone, do you really care if people know who are getting your stuff? By the way, the will does not list assets unless you're making a specific bequest. So in our will questionnaire, we're not even asking people, details on accounts, things like that. We ask them what real estate you have, and ballpark is your assets more or less than $13 million, because federal estate tax starts at $13 million, and maybe some of those richie people in Princeton on the lake have more than $13 million, but most of us South Brunswick and regular people are not $13 million people. There's no real, most people don't need to avoid probate in New Jersey. Yeah, if you spend the money and have a trust done, you're avoiding probate, and the day someone dies, the trustee can start doing stuff. But sometimes, in a way, what's the rush? You still got to go through, sometimes you eventually got to sell the house. So, you always ask people, why do you think you need to have a trust? There's a different kind of trust called an irrevocable trust, Medicaid trust. What that does is you're no longer owning the property. It's irrevocable. There's a new deed. The deed is filed with the county surrogate. You don't own the property anymore. You're not the trustee. Then you got to wait, hope that you don't go into nursing home for 5 years. The attorneys and professionals that do the Medicaid irrevocable trust charge $12,000, $15,000. Basically, that's 1 month in a nursing home. But it's the people usually ask me questions about protecting assets in nursing homes. They're not the senior citizens. It's usually their kids that want to protect their inheritance. And people are in. I see people in my office periodically. Got to fix my flag. But daughter brings mom in because the daughter says, "Oh, mom's concerned about if she has to go into a nursing home." I can tell mom wasn't concerned whatsoever. It was the daughter. I go to the daughter, okay, you want to protect, go out and buy a long-term care insurance on your mom. Well, I don't want to spend my money. Then the daughter goes, what did I do? I go, well, me, hey, let's see, I'm not transferring all my assets out of my name, so I have to go into the dirty, smelly nursing home. Geez, I was a paper boy delivering newspapers in the rain when it was 38 degrees. I worked hard my whole life. I want to go in one of the best nursing homes that exist. I want to go into the nice one. If there's money left over afterwards that my kids are going to get, that's fine. But again, why should I go into the crappy nursing home so my son, Dr. Brennan, can have a bigger boat? I remember both Rockefeller and Carnegie, they didn't leave their kids as billionaires, millionaires. They gave away their assets to charities, let the kids work on their own. I do want to point out that anyone who attends one of our seminars, if they contact us and fill out the short form, in 30 days from the seminar, we do a free consult with them. Otherwise, it's $200. The last thing I'm going to touch though upon trust is we often put trust within the will. That's not a revocable trust. So a common example is I mentioned when there's minors, they don't get the money till they're 21, or if their kids could be 22, 25, 30. Some people have kids that are wayward. Let's say where they have alcohol problems, drug problems, so they can set up what's called a trust within the will, a testamentary trust. One of the executor can be the trustee, and pay for that person, but it's discretionary, so it can't be. They don't lose any Social Security benefits they're getting. It's not subject to taxes, and it's not subject even to alimony or support orders. We got involved with a probate matter out of Somerset County, and there was a motion to compel the trust to pay the ex-wife, spousal support, alimony. I represent the estate. I go, it's a testamentary trust, Judge. That's why you set it up. It's the only thing that taxes, the IRS can't get to it. No one can get to it. And the judge says, yeah, that's correct. That's why people do it. But if someone is an alcoholic, if an alcoholic gets $100, they spend $100 on booze, so we had to kind of protect them from themselves. The people that have special needs kids, they're usually smart enough to know, hey, I want to set up a special needs trust for my child, and there's attorneys that are experts on that. So think about sometimes, your kids are wayward. All right. So we've touched upon wills. We've touched upon revocable trust, testamentary trust, irrevocable trust. Let's talk about powers of attorney. Will takes care of your assets if you pass away. What a power of attorney does is you're giving the power while you're alive to someone that can help you out. They can pay your bills. If a house needs to be sold, the house can be sold. If things need to be purchased for you, they can purchase it. They can act legally upon your behalf. The power of attorney is effective either right away or only upon disability. If it's effective right away, then it's called a durable power of attorney, and it stays effective even if someone becomes disabled, incapacitated. If it's effective only upon disability, that's a springing power of attorney, only if someone becomes disabled pursuant to the statute. I had a client last year who goes, Kenny, I'm a carpenter. I don't understand legal stuff. Explain to me in carpenter language this power of attorney. No problem, Freddie. Listen, if it's effective right away, that's the durable one. Your son, who's your agent, can steal all your money right away. If it's effective only upon disability, he has to get a note from a doctor before he steals your money. Knowing that, do you trust your son? He goes, I trust my son with my life. Well, good. Okay, then let's make let's make it effective right away. Now, the power of attorney, some of the banks and institutions were giving people a hard time. So New Jersey legislature said, listen, if they're doing business in New Jersey, these banks, they have to honor it if it makes reference to the New Jersey statute, but has to make reference to Section 2 of PL 1991 C 95 C 46:2B-11, and those cheap things online don't have that stuff. Have a real attorney do your stuff. Also, though, we do recommend a new power of attorney be signed every 5 years. With the will statute, a will never expires. You know, a will is good forever, but with a power of attorney. There's no statute that says how long it's good for, so we usually say, listen, let's sign a new one every 5 years. The important thing is, though, get your power of attorney done, get your power of attorney done. Once a week, we get a call from someone that says, I need to get power of attorney over mom, dad, my brother, my kid. No, you can't get power of attorney over anyone. They have to affirmatively give it to you. You know, so, you know, I usually, my office, they'll ask the question, maybe someone can't type there in the hospital, but can they talk to us over the phone and say what they want? If the answer is no, well, it's too late for us to do the power of attorney. It should have been done sooner. Get your stuff done. Now, I recommend with the power of attorney, after it's signed, scan it, email it to yourself, agent 1, agent 2, email it to your financial advisor, your accountant, anyone that, you know, kind of does business this way. They know that you've picked one of your kids to help you out. That is important, you know. And this way, you know, it's in their records that there's this family member that can help you out. Next, we're going to talk about, and this is our last document, because I typically only go about 35 minutes, is the Living Will Advance Directive. Your will takes care of your assets if you pass away. Your power of attorney, you're giving someone the ability to help you out if right away. What the living will is, it's you can no longer talk. You can probably never talk again. You're not going to talk. The doctor said no more. So you're giving instructions to hospitals and doctors saying, listen, I don't want to be on feeding tubes. I don't want to be on machines, respirators. Now, we're not talking about if someone is like at ShopRite buying lettuce and they have, a heart attack. It's where, you know, someone is some kind of in a coma. They have some type of terminal condition, you know, and the doctor says they're never going to get up again. It's important because it's an early document for you, so your family does not have to go through with the trauma of what to do. You know, it's so it's an important document to have. I remember, you know, because one time, doctor asked me, okay, should we remove life support today? I go, geez, doctor, I feel bad. I mean, you know, the right decision is for someone who's 92 years old that's never going to, open their eyes again. But you hate to be the one to say, yeah, doctor, go ahead, turn the switch off. So in our powers of attorney, we have what's called a HIPAA authorization. We also put that in the living will. You know, that way you're in addition to saying what your wishes are, someone for the doctors can talk to. And it's very, very important because, you know, typically there's one person in the family that, is always helping out, and then there's one that doesn't help out, but then suddenly someone's at the end, someone's in a hospital, and one of the kids might be barging in saying, okay, I'm in charge now, this is what we're going to do. And the answer is no, you're not in charge, someone else is in charge, and this is what it is. So think about it. Now, there's been many advances in science where the doctors can do things that no one ever imagined. So the doctors will in fact talk to whoever you pick to say, listen, will you want us to try this, or what would you want to do? I kind of joke, when I was first married 33 years ago, I'm redoing my documents, my wife and I, and in the living will, my wife says, oh, I could never let them, you're all lovey-dovey when you're first married. I could never let them remove life support. I go, okay, fine. Let's say I'll leave my father as, the person in the power of attorney, right? But then you have years later where the spouse says, wait a minute, if you die, I get $800,000 tax-free through life insurance. Why keep them alive? The clauses in our living wills that you have DNR, post authorization, and organ donation. After you sign the living will, scan it, email it to yourself, your number 1, your number 2, and your primary doctor. The great thing with scanning it is and emailing it, yet you have it. At least I have an iPhone. It's on. Even if I don't have internet,